Hello everyone, my name is Daria Baklan. I'm professor of National Research University, High School of Economics, Moscow, Russia. First of all, I would like to thank Dr. Amrita Bahri, who invited me to deliver this lecture, specifically focused on trade and climate change, on compatibility between states' obligations under the Paris Agreement and WTO law. As for the content of our lecture, we'll have a very brief introduction, then we'll move to process and production methods, so-called PPMs and lightness. Then we'll focus on legal status of carbon tax under the GATT. Then we'll answer the question, can combating climate change measures be justified under Article 20 of the GATT, and finally, we'll assess applicability of the TBT agreement in the context of combating climate change. Let's start with a brief introduction. And here, I would like to draw your attention that according to the World Meteorological Organization, the 2020 was one of the 3 warmest years on record, with the most notable warmth being observed in the Siberian Arctic, in the coldest city in the world, which you can see on the slide, Verkhoyansk, where average temperature in winter is minus 70 degrees Celsius. Summer temperature in 2020 reached 38 degrees Celsius at Verkhoyansk, provisionally the highest known temperature anywhere north of the Arctic Circle. As you might know, climate change is connected with CO2 emissions and emissions of so-called greenhouse gases into the atmosphere. On the next slide, you can see states responsible for the most greenhouse gases emissions. As you can observe, these states are at the same time the biggest trading nations. Therefore, compatibility between climate law and trade law should be assessed in order to balance trade and combating climate change interests. There are different harmful consequences caused by climate change, like ice melting, water flooding of territories, increasing number of natural disasters, and emerging of new types of diseases. Also, climate change is one of the biggest threats to biodiversity, as soon as it causes alteration or even total destruction of natural habitats of flora and fauna. One of the most illustrative examples is the loss of biodiversity in Arctic region. You can see some examples on the slide, and generally, to date, at least 20 Arctic fauna species are threatened, vulnerable, endangered, or critically endangered due to the consequences of climate change. Now, moving to compatibility between climate law and trade law, it should be noted that Paris Climate Agreement this preamble contains reference to the United Nations Framework Convention on Climate Change, according to which measures taken to combat climate change, including unilateral ones, should not constitute means of arbitrary or unjustifiable discrimination or disguised restriction on international trade. The Paris Agreement is a multilateral treaty ratified by the vast majority of the states on the planet. Only 2 out of 164 WTO members didn't ratify the Paris Agreement, namely Turkey and Yemen. Therefore, most of the states parties to the Paris Agreement are also WTO members and consequently are obliged to follow WTO rules as well. Hence, the issue of compatibility between states' obligations under the Paris Agreement and WTO agreements is on top of the agenda. Article 4.2 of the Paris Agreement enshrines the mandatory provision according to which each party shall prepare, communicate, and maintain so-called SNDCs, successive nationally determined contributions, that it intends to achieve. Parties shall pursue domestic mitigation measures with the aim of achieving the objectives of such contributions. Such kind of measures are mostly connected with the process and production methods, PPMs, aimed at reduction of the greenhouse gases emissions. Therefore, we are moving to our second part on PPMs and likeness of the products. The Organization for Economic Cooperation and Development, OECD, recognizes that there are two sorts of PPMs. First, those which affect characteristics of a product so that the product itself may pollute or degrade the environment when it is consumed or used, so-called product-related PPMs. For example, gasoline. And second, those which not affect product itself and can have a negative impact on the environment through, for example, the release of pollutants into the air or water during the production stage, so-called non-product related PPMs. PPMs related to greenhouse gases emissions are of the second kind. And the question here is whether non-physical, unincorporated characteristics of the product, such as PPMs, could be taken into account for determining likeness of products under the GATT. It might be difficult to establish that two physically similar and competing products are nonetheless not like, based on their respective levels of greenhouse gases emissions, since this is not a product-related criterion, but rather related to the process and production method. At the same time, the appellate body stressed, and I quote, that there can be no one precise and absolute definition of what is like. The concept of likeness is a relative one that invokes the image of an accordion. The accordion of likeness stretches and squeezes in different places as different provisions of the WTO agreement are applied. The width of the accordion in any of those places must be determined by a particular provision in which the term like is encountered, as well as by the context and the circumstances that prevail in any given case to which that provision may apply. Moreover, in each of the provisions where the term like products is used, the term must be interpreted in light of the context, the object and purpose of the provision at issue, and the object and purpose of the covered agreement in which the provision appears. Let's look at the preamble of the Marrakesh Agreement establishing the WTO. It mentions sustainable development as one of its primary objectives. Environmental protection in general and combating climate change in particular is the cornerstone for sustainable development. Sustainable Development Goal 13 of 2015 Sustainable Development Goals specifically focused on climate change. Hence, the notion of likeness under each of the WTO covered agreements must be interpreted in light of the purpose of sustainable development, which includes combating climate change. Moreover, consideration of likeness could be carried out under one out of 4 likeness criteria, namely consumers, tastes, and habits. As you might know, this likeness test was established in the WTO jurisprudence, and one of the likeness criteria is consumers' tastes and habits. In this regard, the appellate body has noted that evidence relating to the health risks associated with a product may be pertinent in an examination of likeness under Article 3.4 of the GATT. Hence, these observations and arguments show that the likeness test leaves room for the consideration of environment-related PPMs under the criterion of consumers' tastes and habits, and such consideration will be in the light of the object of the Marrakesh Agreement establishing the WTO. Now let's move to our next part, which is specifically focused on carbon tax under the GATT. According to Article 3 of the GATT, the contracting parties recognize that internal taxes affecting processing of products should not be applied to imported or domestic products so as to afford protection to domestic production. In the context of compatibility between the Paris Agreement and the GATT, one could argue that word processing refers to those aspects of production that do not affect physical characteristics of the product. And here, I would agree with Just Pauline, underlined that even if technically the carbon tax or charge were levied on producers based on emissions at the production site, rather than directly on products at the point of sale, such tax or charge could still be regarded as applied indirectly to products. These observations confirm that carbon taxes could be subject to WTO law disciplines, in particular Article 3 of the GATT and its add-on. This means that a state being subject to both Paris Agreement and the GATT obligations may apply carbon taxes to fulfill Paris Agreement objectives as long as it complies with the national treatment obligation under Article 3 of the GATT. Now, let's move to our fourth part, and let's answer the question, can PPMs related to combating climate change be justified under GATT's Article 20? Article 20 of the GATT allows WTO members to use measures that would otherwise be GATT inconsistent to pursue certain legitimate policy objectives. Article 20 contains an exhaustive list of public policy exceptions, and 2 of them could be invoked to justify measures applied to combat climate change. Namely, exception necessary to protect human, animal, or plant life or health, or paragraph B of Article 20, and exception relating to the conservation of exhaustible natural resources if such measures are made effective in conjunction with restrictions on domestic production or consumption. According to panel report in China Raw Materials, the two-tier test is needed to justify a measure under Article 20b. A panel must first determine whether the challenged measure falls within the range of policies designed to protect human, animal, or plant life or health. And second, a measure must thereafter ensure that, and panel, second, that the panel must ensure that a measure is necessary to fulfill the invoked policy objective. As for the first element, in Brazil tires, the panel noted that the respondent invoking Article 20b exception has to establish the existence not just of risks to the environment generally, but specifically of risks to animal or plant life or health. This means that for the measure to be justified under Article 20b, it is not enough that the measure merely aimed at combating climate change. It must also be aimed at mitigating the existence of risks to animal life or health. Regarding the second element, the necessity test, the panel must consider the following factors. First, the importance of the interests or values at stake. Second, the extent of the contribution to the achievement of the measure's objective. Finally, its trade restrictiveness, meaning to compare the measure with less trade restrictive alternatives with the same contribution to the objective. As for the first criterion, the importance of the measure, the more vital or important the common interests values pursued, the easier it would be to accept the measure as necessary and as designed to achieve those ends. Fresh air is a global common interest, and it is globally shared natural resource. Climate change is a global problem, and taking into account that most of the WTO members are parties to the Paris Agreement, it should not be problematic for the measure aimed at combating climate change to satisfy first criterion, the importance of the interests or values at stake. As for the second criterion, the extent of the contribution to the achievement of the measure's objective, the appellate body accepted that a measure could be considered necessary even if the contribution of the measure is not immediately observable. This is exactly the case of the measures aimed at combating climate change. Their contribution could be seen only through a long period of time. And Article 14.2 of the Paris Agreement supports this approach, stipulating that Conference of the Parties shall undertake its first global stock taking in 2023, and then every 5 years, unless otherwise decided by the Conference of the Parties. Moving to the third criterion, the criterion of trade restrictiveness and possible less trade restrictive alternatives, it should be noted that it would be the burden of the complaining party to show the existence of less trade restrictive alternatives with the same contribution to combating climate change. For instance, technical regulations and standards with respect to the PPM's process and production methods might be considered as less trade restrictive alternatives than import bans or taxes levied on goods with a high carbon footprint. Therefore, it would be the burden of complainant to show such less trade restrictive alternatives. Now let's move to paragraph G of Article 20 as alternative option to justify measures aimed at combating climate change under Article 20 of the GATT. To justify measures combating climate change under Article 20G, 3 requirements should be satisfied. The first is whether climate could be regarded as an exhaustible natural resource. The notion of exhaustible natural resource was examined by the appellate body in US shrimp case. The appellate body noted that the generic term natural resources in Article 20G is not static. Its content is rather by definition evolutionary. Moreover, the clean air was considered to be exhaustible natural resource by the panel in US gasoline case, where the panel ruled that clean air was a resource, it had value, and it was natural. It could be depleted. Accordingly, the panel found that a policy to reduce the depletion of clean air was a policy to conserve a natural resource within the meaning of Article 20G. Therefore, climate is likely to be considered as an exhaustible natural resource under Article 20G of the GATT. The second criterion or requirement is that the measure should relate to the conservation of climate. The relating to criterion must be considered by looking at the challenged measure in light of its policy and regulatory context and not in isolation. There must be a close and genuine relationship between ends and means. However, such an assessment would not require an evaluation of the actual impact of the concerned measure. Therefore, unlike the necessity test, the assessment of relating to does not require the respondent to establish the contribution of the measure to its objective and the actual impact of the measure. It is sufficient to show that the measure assists, supports, or furthers the objective. Also, there is no need to assess the trade restrictiveness of the measure. With respect to the third requirement, the appellate body noted that Article 20 permits trade measures relating to the conservation of exhaustible natural resources if such trade measures work together with restrictions on domestic production or consumption. This criterion is directly connected with the PPMs, which should operate to conserve climate as exhaustible natural resource. To satisfy this criterion, such measures should work together with restrictions on domestic PPMs connected with greenhouse gases emissions. And the last step of the analysis is the chapeau or introductory clause of Article 20. The chapeau of Article 20 of the GATT requires that the measures shall not be applied in a manner which would constitute a means of arbitrary or unjustifiable discrimination between countries where the same conditions prevail or disguised restriction in international trade. The function of the chapeau of Article 20 is to prevent the abuse of general exceptions. And it is likely that the measures aimed at combating climate change face the same difficulties that the United States measures faced in US shrimp case. First, the respondent might be accused for forcing other WTO members to adopt environmental standards that are essentially the same or very similar to its own standards. Second, other WTO members might show that they already have measures in place to promote their climate policy. Third, it would be burdensome for the respondent to multilaterally negotiate with WTO members an agreement or understanding that aims to reduce greenhouse gas emissions. Now let's briefly look at applicability of agreement on technical barriers to trade and PPMs. This agreement could be another effective tool to fulfill Paris Agreement obligations. While the TBT agreement explicitly refers to PPMs, it doesn't define this notion. Annex 1 of the TBT agreement defines technical regulation as follows. It's a document which lays down products' characteristics or their related process and production methods, with which compliance is mandatory. It may also include or deal exclusively with labeling requirements as they apply to a product, process, or production methods. Therefore, all technical regulations, standards in the form of labeling requirements regarding non-incorporated PPMs, including those which contain information in respect of greenhouse gases emitted in the process of production, may fall under the scope of the TBT agreement. Now, coming to the conclusion, it is worth noting that despite their different objectives, the Paris Agreement and WTO agreement are complementary in terms of their distributional consequences of climate change policies. Second, now it is a question of particular implementation of measures aiming at the fulfillment of Paris Agreement objectives in accordance with WTO legal regime. And third, most of these measures are connected with the process and production method. And finally, WTO legal regime could be seen as the most effective instrument to fulfill Paris Agreement objectives. Thank you very much for your attention.